Hey guys, hope everybody's doing well. If you haven't tuned in, there haven't really been recent Courtney Clenney updates. I think the last major update was back in June with the motion to disqualify the state attorney's office, the Miami-Dade County, from prosecuting this case. That was denied. Prior to that, the former lead prosecutor stepped down, and now the lead prosecutor is Sean Abahoff. But yeah, the big news, the last time we met, we said, hey, we might get a trial in 2025. And lo and behold, for now, unless something comes up, we have a December 1st, 2025 trial date. This case stems back to the April 3rd, 2022 killing of Christian Obumseli. So this has been a long time in the making. I would say the biggest detail is that trial date. We will be covering it on this channel. We'll stream it live. So subscribe if you want to watch it here. If you want to get caught up on the case, there is a playlist linked in the description. It's got all of the bigger motions, some of the hearings, the body cam footage from 3 different angles, which that was a lot of crazy stuff going on. We talked about justification and looked at Florida's statutes as they relate to this case. Just a whole bunch of stuff. And sometime between now and December 1st, we'll also take a look at the Arthur hearing. So I think that was November 2022. I think it was like 8 hours total. In Florida, an Arthur hearing is a bond hearing for serious offenses. So we could go and do a live stream maybe the week before trial set to start. We'll look back at that. A bond hearing almost is like a little bit of a miniature trial because the state's trying to present why they think someone should be denied a bond, all of the bad things that they did. And the defense is trying to say, well, no, all of these different factors, they have ties to the community. They're not a threat to anyone. They're not a threat to public safety. They're willing to abide by these terms. And in this case, the defense started to offer some of their theories of defense. So it'll be really interesting to watch that. And then the last thing, if we take a look at the docket, let's look at the docket updates. The Miami-Dade clerk updated their whole system. So it's new. You'll have to go to miamidadeclerk.gov to get to it. The old link didn't work for me anymore. But it's a lot cleaner. And now you can actually you can download scanned images of documents for free. I haven't had to pay for anything. I haven't had to send in requests to get them. It's awesome. So we're going to look at these 2 things. And we also have a new judge. So I saw that these 2 motions were written for Judge Andrea Ricker Wolfson. I haven't actually watched any trials with that judge. And I liked Laura Sharon Cruz. I don't see anything on her hearing schedule, so I don't know if maybe she's leaving or retiring, or if this judge just was assigned for the trial part of this case. But does anybody recognize the name Andrea Ricker Wolfson? The reason I ask, especially as it relates to motions to disqualify prosecutors, is last year she made a pretty newsworthy decision to disqualify 2 prosecutors from the case of Corey Smith. So I'll drop a link to this in the chat if you want to check this story out, but I'm interested in seeing what this judge is like. And then get back over to this docket. They haven't updated the next hearing yet, but it looks like they have dates set for a status check, and also they'll want to know if any pleas are offered and are accepted, rather, on October 15th. So I'll keep an eye on the docket for any motions that come in between then and now, but that might be like the next day of interest. I don't know if I think they'll offer a deal to Clenney, but we'll see. And again, just because they offer one doesn't mean that Clenney will accept it. I don't know if I think she would accept a deal. I think the only thing that would help in that regard is a few months ago, it was reported that Courtney Clenney put her house up for sale. And if she's offered a deal, maybe the financial burden would move her towards feeling like she has no choice but to accept the deal. But based on the what I would say is a vigorous advocacy so far, I can't imagine her not wanting to maintain her innocence and take it to trial. But you never know. On the 20th of November, there's a felony sounding set. Now, that's another Florida term, just like the Arthur hearing is a bond hearing. In Florida, a felony sounding set is just, look, 10 days before trial, we're going to get together and both sides are going to tell me if they're ready for trial. And then trial is set to start at 9, December 1st. This will be like pre-trial stuff, making sure voir dire questions, everything like that, ready to go. And can we get the jury in to start asking questions? So don't anticipate we'll be watching opening statements on day 1, but maybe within that week time frame. But let's look at these quick motion updates. The first one here, well, and this is going to be stupid to open. Let me find a better way to open this so you guys can see it real good. Let me put this in a Google Drive quick. And what we're going to be looking at is a motion. Okay, well, this is definitely being stupid. Maybe this will work. Let's see if it loads. Let's hope for the best. It doesn't want us to look at it. Well, who knows? Gotta love it. But we'll make it work, guys. I'll try to read real clear. So this is a motion in limine. What do they want to argue about? Well, they want this ruling on the CGI animation as demonstrative evidence. The CGI animation is going to relate to the floor plan of the One Paraiso penthouse apartment where Courtney and Christian lived. So it comes now, the defendant, they do the same thing that Georgia does, you guys, but this comes now. By and through undersigned counsel, respectfully moves this honorable court for a pretrial ruling on the admissibility of a computer-generated animation to be introduced as demonstrative evidence at trial, contingent on laying proper foundation. So, quick background, and we'll read this time because it's been a while since we've talked about this case. So, the general factual background. Courtney Clenney is charged with second-degree murder in the death of Christian Obumseli, which occurred inside her apartment on April 3rd, 2022. No witnesses were present during the incident. The defense has filed a notice of battered spouse syndrome under Florida law and will argue that Clenney's actions were justified as she was defending herself. The City of Miami Crime Scene Unit conducted Faro 3D scans, generating over 2.7 gigabytes of spatial imaging, and produced crime scene photographs, diagrams, and a written report. Defendant's recorded video statement has also been provided. These materials have been reviewed by Jason Fries of 3D Forensics, who has determined that they are sufficient to create a CGI animation recreating the defendant's account of events. So, a few months ago, we got this knife throwing expert to do a recreation of a knife throwing to see if, with a single fling of a knife, throwing the knife as Courtney Clenney describes throwing the knife, flinging the knife from 10 feet away, in her recorded interview with detectives. We have those videos of a guy, and it's not animated, it's like a real guy doing the demonstrative throwing. Now we want to get a CGI animation because we can use this Faro, and this Faro stuff was submitted by the state. Here's the floor plan, here's all of what the crime scene looks like. Now the defense wants to have Jason Fries create a CGI animation of what Courtney says was happening in those moments. So, the CGI animation would be used only if defendant testifies. And this is why I thought this was so interesting, because is this very good prep work for a very small chance of something? Or is this, we're planning to put this defendant on the stand because we need her to establish what she's claiming, elements of the self-defense and battered spouse syndrome. And there's evidence that could only come from her. So it seems like they might be planning to put her on the stand, and in doing so, want this visualization to help explain what she's describing. So, yeah, I agree, Michelle. This is a good way to put it. You never disappoint. So this will be a time. Mr. Fries will testify only to the creation of the animation, including the software used, its reliability, and the process by which Faro scans and police data were incorporated. He will not interpret the facts or opine on the ultimate issue. Now we've got to get through, and I think this is interesting, right? I've never really looked at statutes, case law relating to this type of admissibility. I've always just kind of thought like, well, isn't that kind of steering the jury? Even video, like video surveillance recordings, real video that's showing you something happening in real time, can give you a skewed perspective on what was happening in that moment. Real video, not something that somebody creates based on something else. But think of like with football, when American football, when they roll back the footage, they do the replay to see, was the ball down, was the knee touching the ground before the ball crossed into the end zone, and they have to play it from like 3 different angles. And from one angle it'll be like, oh, it's in the clear, it's good, and then from another it's like, oh nope, no it's not. So real video can be misleading. So the idea of using CGI animations to demonstrate something, to me, is a whole nother level. But let's see what they argue is the legal standard. So the defense seeks a pretrial ruling on the admissibility of a computer-generated animation that lays out a visual of what occurred in the apartment on April 3rd, 2022, leading up to the moment when Courtney Clenney threw a knife to defend her life against Obam Selly. The animation would be introduced as demonstrative evidence to aid in the testimony of Clenney. According to Florida's Rules of Evidence 90.702, if scientific, technical, or other specialized, and I think we're going to lean heavily on this or other specialized knowledge will assist the trier of fact, so the jury, in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if 1, the testimony is based upon sufficient facts or data. 2, the testimony is the product of reliable principles and methods. And 3, the witness has applied the principles and methods reliably to the facts of the case. The defense understands that this court cannot make a final ruling until trial and only upon review of the completed animation and live testimony. However, a preliminary ruling that such an animation will be admissible upon foundation would allow the defense to proceed with production and conserve financial resources. So this is their explanation of why they're asking for this request right now. The defense seeks, can you imagine if the state goes and does their own CGI? They let this CGI in, and then it becomes a trial of competing CGI renders. December 1st of this year, 2025. I feel like we have to say the year. And Brittany, I'm with you. They're going to put her on the stand and she's going to sound ridiculous, especially when all the journal notes, the body cams, and all that comes in. And I'll tell you this, if I was a prosecutor, especially, I'd imagine by the time she gets on the stand, a lot of those things will already be admitted in evidence. I'd be like, can you describe what you're doing in this one? What about in this one? What about in this one? Oh, man. It will be a trial. It will be a trial. Sabata says the fact she wants to use AI as part of her defense is just a sign of the times. Have you guys seen the stories of, I think there's been more than one now, so I'm saying stories, but maybe I'm confusing situations, where for a sentencing hearing, victim impact, the deceased, there was an AI generated video animation of the deceased speaking about his loss of life. I thought that was I don't really know philosophically what to do with that. Because somebody else had to create that. That's not really like this person didn't record a hologram of themselves before they passed away with their own words. That's somebody else creating something with their likeness to use it to address the court for terms of sentencing. So, yeah, and now to see it at the stuff like this entering the guilt phase of a trial is a whole nother thing. So, but we're gonna have, so the defense says they're gonna call Jason Fries, maybe it's Fries, for the limited purpose of authenticating the computer-generated animation. Mr. Fries will testify regarding the methodology and process used to create the animation, including that the data was derived from the Faro 3D scans, along with crime scene reports, diagrams, and photographs prepared by law enforcement and produced by the state attorney's office in discovery. His testimony will verify the accuracy and reliability of the visual depiction of the apartments and its contents as they existed on the date in question. The animated sequence will be based on the above, provided by law enforcement. This is kind of funny because you trust them, right? Those are your people. You think that everything they provided is sound, right? So if we base it on what they're saying, it should be good, right? They keep leaning into this being provided by them. And the narrative provided by Courtney Clenney. The computer-generated animation is intended to illustrate and assist her testimony by providing a visual representation of the event she describes. Mr. Fries will not offer any opinion on the facts or ultimate issues in the case. Computer-generated, so we're going to get some case law now. Computer-generated animations, while generally seen in civil cases, have consistently been permitted as demonstrative evidence, provided a proper foundation is laid and the animation is a fair and accurate depiction of the testimony it supports. In Pierce v. State, so this is the Florida District Court of Appeals from 1997. The court upheld the use of a CGI animation in a criminal case, holding that the Fry analysis, not Fries, a different analysis, was unnecessary since the animation was introduced as demonstrative and not substantive evidence. So we have a footnote. Although Pierce applied the Fry standard, is Fry standard like the old Daubert? Yep, so Fry standard, legal standard used in the United States to determine the admissibility of scientific evidence, in contrast with the Daubert standard. So that's, I knew I remembered that name. But let's see. So they were using the Fry standard for admission during this trial, this underlying trial. The court found it inapplicable because the animation was demonstrative and not substantive evidence. Since that time, Florida has adopted the Daubert standard for expert testimony under statute 90.702. However, Daubert, like Fry, governs the admissibility of expert opinions, not the use of demonstrative aids that simply illustrate a witness's testimony. Accordingly, the rationale in Pierce applies with equal force under Daubert. If the animation is offered solely to assist the trier of fact in understanding testimony, not as a scientific conclusion, Daubert analysis is not triggered. So that'll be a time. What else? I think we have another case. So they're going to cite here United States v. Garcia. It's a Ninth Circuit case from 1993. It's a bit blowing my mind that this is not as new as I was thinking. Animations used as demonstrative exhibits to illustrate testimony are not subject to Daubert because they are not themselves evidence, but rather explanatory tools. So see United States v. Salim. This is okay, we're getting into 2002 now. We're in the 2000s. This is a Southern District of New York case. The court in Pierce relied upon the expert's testimony that, quote, computer animation consists of individual pictures shown in rapid sequence to indicate motion. The animation was a fair and accurate representation of what it purported to depict, and that the data, information, and evidence utilized was a type reasonably relied upon by experts in the field of forensic animation. That's a fun field. That sounds like a super fun field. In making its determination on reliability, forensic animation. I'm just thinking of like Disney movies and all of that, but in the application of can we demonstrate how this event went down? Just get some Pixar characters in here to show the jury. In making its determination on reliability, the court cited to People versus McHugh. That was we're over in the Supreme. Oh, okay, cool. So that's a Supreme Court case in New York. Um, guys, have you guys ever heard my rant about how confusing the organization of the court system in New York is? Like, the Supreme Court in New York is not the highest level. It's just weird. In making its determination on reliability, the court cited to People v. McHugh, where the court observed, a computer is not a gimmick, and the court should not be shy about its use when proper. What is important is that the presentation be relevant, that it fairly and accurately reflect the oral testimony offered. So that's why, they're going to pair it with Courtney. And that it be an aid to the jury's understanding of the issue. So that's why we're requesting this preliminary ruling, that it may be introduced as demonstrative evidence subject to proper foundation at trial. So there we go. There we go. Yeah, is it the lowest level? I don't know. The court system in New York is so confusing to me. Oh, Touche, I'm with you. Touche says, I'm sorry, I'm trying to be open, but it's hard for me to see this case without a biased opinion based on what we know already. I agree, and at the same time, I don't know if this waiting so long for trial could help. Miami is a huge place. I'm sure there's people that never heard a drop about this, but still you have to call a large enough jury pool to see what they heard. Or maybe you have to lean into a strategy, like if you're the defense, maybe you want to lean into the strategy where you're okay with seating people that may have initially heard about the case, but they're open-minded. Maybe they didn't see some of the more inflammatory things that were in the media. Maybe they just heard the details of the arrest. All right, well, maybe we want this jury to be with us because maybe they'll hear, hey, things are a little bit different than how it was initially reported, and maybe that can pull that juror to reasonable doubt. But I'm with you. If a lot of the stuff that we saw, and for me, I'm stuck on one little journal note. This is something she wrote in her notes app in her phone that's saved through, I guess it's Notes is an Apple app. So even if you get a new phone, it's stored in your Apple iCloud. I don't know if those journal notes are going to be admissible, but if they are, and if this one note is admissible, she spells out a year and a half before Christian Obumseli's killed that she hits him and throws things at him with the intent to relieve tension and stress, relieve her own emotions. That's not very good if you're trying to raise a self-defense justification or rely on battered spouse syndrome as a defense. Really not a good thing to notate in your own words in a place that you don't think other people are going to look. It's not somebody else saying that about you. Or you're just someone's asking you and you concede because you just want to tell them what they want to hear so they stop fighting with you. This is just her venting to herself in her journal. You've got to stop throwing things at him just to relieve your own anger. So that's a time. And those journal notes, we did readings. I don't remember. Oh, I put it in the title here. So it's this there were 3 videos that I think we did on this. Oh, let me open it so I can give you a link to this one. We looked at others in this one as well. But if you wanted to go and hear that one little bit, maybe I timestamped it. All right, we can jump over and watch me real quick. I'll play the exact segment. So I'll hide myself while I listen to myself.
Then on 8/28, words hurt, name calling. Parentheses, asshole, mooch, fake, etc. Bringing up trauma, parentheses, i.e. dad. Now, if you watched any of my early Courtney Clenney content, I got upset with the state. And if you watch my recent stuff, you know I've had some criticism of them now. But in the beginning, I was pretty lenient towards them. I was like, all right, glad they finally brought charges. They're looking into this. They're taking it a bit more seriously. Let's see where it goes. But at one point, it seemed like they were asking for a gag order against the defense. And then when the hearing for it started, they had a pretty narrow request. One of their main points of contention was that Frank Prieto went on an interview with Court TV, not Courtney TV, and started to talk about how Christian Obumseli was the victim of SA abuse by his father. And the state wanted a gag order against Frank Prieto for going on and saying that. And at the time, I was like, well, if it's out of left field and that's a very narrow scope, that kind of makes sense. It's way better than asking for a gag order against someone who has the right and the duty to defend their client in the public arena. But now, even that narrow scope, I don't feel very lenient or forgiving towards because there's a basis for it here. Courtney's the one that mentions it. It's not like Frank Prieto pulled it out of thin air and just decided to allege it. The only problem there is during that motion hearing, Frank Prieto didn't get specific and argue back to fight that type of constraint on speaking about that publicly. But he potentially could have said in that hearing, well, Your Honor, that's not just something I'm running out here and trying to smear the alleged victim in this case, but, it's something that I heard from someone that knew Christian Obumseli very well. But he didn't make that counter argument. But here we are reading the notes and we see bringing up trauma, i.e. dad, and this is Courtney's notes. Courtney was, at the very least, one of the sources of that information, as Frank Prieto knows it. But the note goes on, talking about my tattoo or ring. Now, in that Vegas questioning where she's on the body cam, she does mention that they were talking about a tattoo she.
I'm just going to read this because I went into all the case details here. Past Cat is on a tangent. Let me cover me. So, this is a note. This is when after they were on vacation, or maybe while they were still on vacation on August 28th, 2001. So, this is several months before the April 2022 killing. So, words hurt, the name calling, like asshole, mooch, fake, etc. Bringing up trauma, i.e. dad. So, presumably, Courtney Clenney's bringing up trauma about Christian Obumseli's dad to Christian. Talking about my tattoo or ring, threatening to break up when I truthfully don't mean it. Screaming is unnecessary and causes disruption to others. Physical. She has a words hurt list, and now she has a physical list. Putting marks on his body that make him self-conscious or hurt in general. Coming close to really, this is capitalized, hurting him. Gives the example of the bottle in Tulum. I don't know how to pronounce anything. So should not risk it if for no other reason. Causes security to get involved. Both have now had to be in jail, etc., or kicked out of hotels. So this is where I think I went on to say it in this video. It seems like maybe she was in therapy or talking to somebody, and this is the notes that were relayed to her. And then let me see if it scrolls forward. All right, so then the overall, put yourself in his shoes, recognize his perspective, think before you speak, deep breath or time apart, speak in love instead of in anger, think of the lasting emotional effects and trust issues beforehand. Stop putting your hands on him out of anger. It releases tension, but has long-lasting effects on his self-esteem, looking in the mirror, and is not acceptable in any relationship in general. So again, I don't know if this is going to be admissible in trial for a million number of different reasons, right? It's talking about past incidents. It could be, she, I don't know if this would fall under psychiatry or where this is coming from, but if it's coming from someone in relation to something that would be protected, sure, it's in this phone, but maybe they can make an argument that this is a bit higher of a thing to let in. So I don't know if it'll come in. But it seems like she's taking note here, either for herself or someone else is making these notes based on what she was telling to them, that she hits Christian Obumseli to release tension. That's her intent. That's the intent behind the physical violence. But at trial, she's going to rely on a battered spouse syndrome defense and argue that her killing of Christian Obumseli was justified. And there's other notes where she talks about other physical fights and breaking open a stitched closed cut on his face that she caused a few weeks earlier. She hits him on the face and the stitches break and it oozes back out again. So I would be, it would be wrong for me to sit on that jury. It would be 1,000,000% wrong for me to sit on that jury pool. And we just finished this. And then the other thing on the docket was a notice of taking deposition. Not really that interesting. It's just we're getting closer to trial, and now we see that the defense plans to take the depositions, and it's only 15 minutes scheduled for each of them, like back to back, of the different officers from the Miami Police Department and then the fire department. So this looks like a set of 1, 2, 3, 4, 5, 6, 7, 8, 9 of the first responders that may have responded on April 3rd of 2022. So that's where we are, guys. I think that wraps it up for new updates. Let me refresh. Oh, I never switched over to the depot. It's just the names of the PD and fire department. Real short and sweet. But that's that. Let me refresh the docket, see if there's anything else. Oh, what else is interesting? So a while ago when the laptop case was happening, and Courtney Clenney was named as a defendant in that laptop case, the separate case number. So it was her and her parents. That was dropped, but at that time, this charge was added, and it's still here. So I'm interested in seeing what this interception of wire communications felony charge, what's the underlying cause of that. I never got to see any text documenting, why it was added as a charge. But it's still here, so that'll be interesting to see what exactly that relates back to. And then let's see what you guys are saying. Yeah, everyone's in here like, this is how I found you, Kat. Yay! It's interesting because I wasn't planning on covering this at first. I looked at it, I was like, to me it seems pretty clear cut. I also, I don't know, I like to go live and cover things that are interesting to me in a certain way, and I don't really like to cover clear cut cases unless there's something interesting in it, like a Jim McIntyre or these. You guys know already. If you guys hang out with me enough, you know the things that I find interesting, crazy, all these extra layers. But I was like, okay, this seems pretty cut and dry. Like, what are we going to be doing here? But then all of this mess started to come into play with the prosecution and defense attorneys going at war with each other and the parents getting arrested. And then the state messed up and violated attorney-client privilege. So in my opinion, the state had a gimme case. You can go in and you can try this case, and I don't see, a big possibility that they would lose. They're not overcharging. I don't think they're overcharging. She's facing murder 2 with a weapon. She admits to using a weapon. I don't know. They're not like tacking on all these other extra little things. So I don't know. But all that mess made me want to cover it. Oh, interesting. So Amber Dawn Them Johnson says, hey Slime, in the Queso trial, they did some kind of AI CGI presentation, but it was putting the animation in motion to show the characteristics of the accused is really them. And that was a Florida case, right? Jacksonville? And interestingly, Tara Kawas, she represented Queso. But she's also done work representing Courtney Clenney. I think I've seen her more in relation to all the laptop shenanigans. And really, I've seen Frank Prieto and Sabrina Puglisi more so with, the day-to-day hearings about the trial, the criminal felony murder trial. So, but yeah, so if you watch the Queso trial, you might remember Tara Kawas, who's sitting here on the left in this picture. Yeah, and that might be it, Michelle. That could be an anger management thing. I just knew she had different notes in her journals about having appointments before she would be scheduled new medication, or before surgery. She'd have to go and make sure, like, before you get plastic surgery, I think you're supposed to have an appointment. I don't really know how it works, but yeah. Oh my gosh, Johnny and Dizzy both have the face. I love this. Well, Johnny's is a Lego head, now that I'm looking at it closer. Oh, but I love this. Whew. Yeah, SD, I don't think she's gonna be... I think it might be in her interest to take some sort of plea, especially with the financial considerations. I don't think she's gonna want to. And for what it's worth, guys, I think her defense is fighting very, very hard for her. I mean, I had some, like, vibes seeing them do so many interviews with Court TV and some of the things that they would say to the media, like, all right, you're really trying. You're really trying. But at the same time, when it comes to what they're doing in the courtroom, they are making all the arguments they can make. And I think she's getting well above beyond average representation here. Well beyond above average. And I wish everybody could, I wish we could move the average standard further up on the quality scale. Oh no, not Sarah Boone 2.0. I don't think she's written a bunch of letters or made a poster yet. No, they're not going to be there together. Oh man. Yeah, FFS thinks if she doesn't take a plea, they're going to smoke her. Just my opinion. Yeah, plenty of fans and pen pals putting money on her books. KP, hold on. There's that crazy scale. KP says she was so pretty. I hate that she's a nutcase. But good morning, beautiful people. I can't judge a book by its cover. And what do we got going? Let me double check. I mentioned 2 other cases today. The Hallie and DDG stuff going on, that's Los Angeles, so I mean, that probably didn't start yet. And then Laura Karen. Let's see if there's a Laura Karen update. Those are the 3 cases. And then we'll wrap this up and we'll fire up another stream in an hour from now for day 5 of the Wolfenbarger trial, which is just a whole mess, guys. An entire mess. Let's see. Latest post on Laura Karen. Nothing today. Let me check Google. All right, so no updates, but there's supposed to be a hearing for Laura Karen. That's the New Jersey 5th grade teacher that's accused of having a baby with a 13-year-old student. So that's the time. But we'll look for an update. Maybe we'll cover that briefly if we see any updates on one of the breaks for the Wolfenbarger. Yeah, it is less than an hour now at this point. I think I said this to redirect over to Dolly Talk, who's doing a court roulette, just hopping around to different judges around the country that have the live feeds. So go hang out with Dolly. See, there's some good judges. I like watching those, like, misdemeanor courts. It's really interesting sometimes, and a nice break from the gruesome felony, dismemberment, like brutally killing your loved one, all of that type of stuff. It's a nice break just to see someone, like, have a traffic citation, or like I don't know. Maybe they got, like, a harassment charge because they cursed at an officer or something. It's a nice little break. They should be on time, SD, because I think Kraus gave way more room. Instead of starting at like 10:30 or 11, she just had come at 12:30 Eastern time, guys. So, well, if they don't start on time, we'll rewatch some clips and get some of the details straight. We'll look at some timelines and names and try to get our ducks in a row using the great work of Lexi the Law Nerd. Um, oh wait, is this Adelson, Dizzy? Well, let me see. Michelle loves Simpson and Middleton. Yep, great judges to watch. I think this is about Adelson. So they're ready for opening statements tomorrow now. Dang, they moved that jury selection right along. Guys, so if you are looking to watch Adelson, I was watching Evening last night with Justice Serve TV. They had Michael Easter on to talk about it. There's a ton of creators that are doing live trial streams for Adelson, so I don't want to like list off 10 people and forget an 11th. Like, as much as I love to shout people out, I don't want to give an incomplete list and offend anybody. But seriously, just do a search for Adelson Trial Live, and I'm sure you'll see familiar faces, and find a chat with people you know and would be happy to watch with. And you guys can share what you guys are going to be watching. All right, so Dizzy, not Dizzy personally, but Dizzy says JSTV, and the chat, which Dizzy's a part of, will be streaming opening statements. So don't search for Dizzy, search for Justice Serve TV. And there we go, you guys. See you in about an hour here for more Waffleburger, Wolfenbarger, and any small updates on Clenney I'll tweet about, but if we get a new motion or anything before these hearings, or maybe a plea, look out for a live in the next few weeks. Hopefully, though, we can get this trial, if they take it to trial, we can get it going before the end of the year. Finally. So thanks, guys. And are you late, Wayne? Good to see you, Wayne. Let's get out of here. Bye, guys.